And here's what's interesting. The opinion also pointed out that the state didn't just fail to find meaningful historical support. It actually tried to stretch history in ways that simply didn't hold up under scrutiny. The judges were pretty direct about the fact that many of the laws cited by the state weren't even focused on ammunition, or had little to no relevance to individual rights in the context of civilian self-defense. For example, some of the examples involved regulations during wartime or laws targeting specific types of dangerous individuals. None of them came close to justifying a blanket restriction on every law-abiding resident trying to buy a box of ammo at a local store. Another critical detail the court noted was the impact of the law in practice. While it might look like a reasonable system on paper, in reality, it led to thousands of lawful citizens being wrongly denied ammunition purchases because of database mismatches, clerical errors, or outdated registration records. The system was riddled with issues, and the burdens placed on people just trying to exercise their constitutional rights went far beyond what the law could justify. This is also about precedent. This case reinforces how the Bruen decision has shifted the entire legal landscape when it comes to gun rights. No longer can states rely on vague public safety arguments or draw parallels to unrelated regulations from 100 years ago. Now, they have to prove that a modern restriction has deep roots in American history, and in the case of this ammo background check law, California just couldn't do it. But even with this win, it's important to stay grounded. What we have now is a strong decision from a three-judge panel, but the state still has the option to request what's called an banc review. That means instead of just three judges, a larger group of judges from the Ninth Circuit would rehear the case and issue a new ruling. And given the track record of the Ninth Circuit, it's no guarantee that this victory will hold. The full court has often leaned toward the state in similar cases, sometimes reversing decisions that favor individual gun rights. Still, this case has a different feel to it. The reasoning in the opinion is solid, and the way it dismantles the state's arguments shows how courts are starting to take the historical test from Bruen seriously. It's not just about whether a regulation sounds reasonable. It's about whether it has a foundation in the kind of history the Constitution protects. That's a major shift in thinking, and it sets the stage for future challenges to gun control laws across the country. We should also consider the broader implications. California isn't the only state with restrictive ammunition laws or aggressive gun regulations. A ruling like this could serve as a blueprint for litigation in other places. When a high-profile court like the Ninth Circuit draws a hard line against overreach, it sends a signal nationwide. States that try to implement similar laws might think twice, or at least face a tougher time defending them in court. It's also a wake-up call for how legislative overreach can backfire. Prop 63 was passed with strong public support at the time, framed as a common-sense measure to keep ammunition out of the wrong hands. But the implementation was flawed from the start. Instead of targeting criminals, it put obstacles in front of lawful citizens and created a bureaucratic mess that didn't deliver real safety outcomes. That kind of overreach is exactly why courts exist, to make sure constitutional boundaries aren't ignored in the name of good intentions. And here's what's interesting. The opinion also pointed out that the state didn't just fail to find meaningful historical support. It actually tried to stretch history in ways that simply didn't hold up under scrutiny. The judges were pretty direct about the fact that many of the laws cited by the state weren't even focused on ammunition or had little to no relevance to individual rights in the context of civilian self-defense. For example, some of the comparisons involved regulations imposed during wartime or laws that were designed to restrict access for certain dangerous groups, rather than impose a broad system that affects every lawful citizen trying to buy a box of ammo. Another critical detail the court noted was how this law worked in practice. While the policy might have been promoted as a safety measure, the reality was that it denied thousands of legal gun owners the ability to purchase ammunition, not because they were prohibited persons, but because of clerical errors, mismatched records, or outdated database information. These weren't rare glitches. They were systematic flaws that caused serious barriers for people simply trying to comply with the law. And those barriers weren't trivial. For many, being denied the ability to purchase ammunition meant being denied the ability to effectively exercise their constitutional right to self-defense. This case also marks another clear example of how the Bruen decision is reshaping Second Amendment litigation. Under the older legal tests, Courts might have upheld California's ammunition law by deferring to the state's claimed interest in preventing crime or controlling access to dangerous weapons. But Bruen changed all that. Now, courts don't get to weigh modern public safety goals against individual rights. Instead, if the law in question impacts conduct protected by the Second Amendment, the burden is on the government to demonstrate that it aligns with this country's historical tradition of firearm regulation. That's a much higher bar to clear. And in this case, California simply could not clear that bar. The historical analogs they offered were either too general, too recent, or too far removed from the kind of sweeping regulation the state tried to justify. The court didn't mince words when rejecting those comparisons, making it clear that the government can't rely on vague or out-of-context history to support a modern restriction that fundamentally alters how citizens access something as basic as ammunition. Even with this clear victory, it's important to keep in mind that the legal fight might not be over. The state has the right to request an en banc hearing, which would involve a larger group of judges from the Ninth Circuit reviewing the case. Historically, the Ninth Circuit has not been a friendly venue for gun rights advocates, so there's always a risk that an en banc panel could overturn this decision. But here's the difference this time. California has lost at the district level and again at the appellate level. That momentum matters. It shifts the burden and raises the stakes for the state if they choose to keep fighting. What stands out most in this opinion is how thoroughly the court dismantled the state's rationale. This wasn't a narrow decision. It was a broad, well-reasoned critique of a law that overstepped its constitutional boundaries. The judges didn't just say the policy was flawed, they said it failed every step of the new constitutional test, from lacking historical precedent to causing excessive real-world harm. That level of clarity sends a powerful message, not only within California but to the rest of the country as well, because California is often seen as a testing ground for aggressive firearm restrictions. This ruling has implications far beyond one state. Other jurisdictions considering similar rules might now think twice. Laws that once seemed politically safe or popular could now be legally vulnerable. And for those who have been working tirelessly to challenge laws like these, this moment serves as confirmation that the judicial system is starting to respond in a more principled, constitutionally grounded way. This case is also a cautionary tale for lawmakers. Even policies that sound like common sense or have public support can still cross the line if they trample on fundamental rights. The courts are no longer giving states a free pass when it comes to Second Amendment restrictions. That's the new reality after Bruen, and it's one that every lawmaker, judge, and citizen should pay attention to. Even as we celebrate this victory, it's important to understand that what just happened is not the final chapter. It's a pivotal moment, but it exists within a much larger legal and cultural conversation. California's Attorney General may still move for a full en banc review, and if that happens, we could see a reversal if enough judges on the full Ninth Circuit decide to side with the state. That's why momentum matters so much. Every win like this builds a stronger foundation for future cases, reinforcing the legal standard that is now expected under the Second Amendment. Looking ahead, this ruling could serve as ammunition, no pun intended, for challenging similar laws in places like New York, New Jersey, or Massachusetts. These states often mirror each other when it comes to regulatory approaches, especially around firearms. Now that the Ninth Circuit has delivered such a clear message about what does and doesn't pass constitutional muster, attorneys in other circuits have something concrete to reference. They can point to this case as a benchmark, and judges in those circuits may feel more confident pushing back against overly broad or historically unsupported restrictions. The other side of this story is how long it took to get here. Rhode v. Bonta wasn't a case that moved quickly. It dragged through the courts for nearly 6 years. That timeline highlights just how difficult it is to undo bad legislation once it's been passed and enforced. Legal teams have to navigate through trial courts, appeals, injunctions, stays, and mountains of paperwork. But in the end, persistence paid off. It shows that no matter how entrenched a law may seem, it can still be taken down if it violates core constitutional principles. There's also a broader cultural impact at play here. For years, gun control advocates have pushed the narrative that anything labeled as common sense should be above scrutiny. But laws that limit fundamental rights should never be beyond questioning. What's becoming clear is that the Second Amendment is being restored to its proper place in the Bill of Rights, not as a second-class protection, but as a fully enforceable individual right. Courts are beginning to say that clearly and more frequently. For those following this space closely, it's an encouraging sign that things are shifting, not overnight and not without setbacks, but step by step through serious legal effort and a renewed understanding of what the Constitution demands. Whether or not this case is the end of the road, it will be remembered as a key turning point. And for anyone who believes that rights matter even when they're inconvenient for politicians, this win is worth recognizing. So, as of the end of July 2025, we're looking at a legal climate that feels very different than it did just a few years ago. What happens next is uncertain. But what's certain right now is that the courts are listening. And when laws go too far, when they break from our nation's legal tradition and put politics over principle, those laws can be defeated.